Welcome, everyone. Welcome and good afternoon. I'm Gary Jenkins, the Dean of the Law School, and we are delighted to have all of you join us for this great occasion, the investiture of Professor Heidi Kitrosser as the Robbins Kaplan Professor of Law. It's always great to see so many faculty and students and friends. At the conclusion of the lecture, I hope that you will all join us upstairs, one level up in the Auerbach Commons for a reception. So please join us for some light refreshments at that time. So an investiture of a named professorship is especially meaningful in higher education. It acknowledges the highest level of academic accomplishment in research, in teaching, and in public service excellence. It's a time to celebrate the honoree, but also to honor the donors who make academic excellence possible. In this case, the donor is one of the nation's leading national law firms, Robbins Kaplan. Founded in 1938, right here in Minneapolis, by two of our graduates, Solly Robbins, class of 36, and Julius Davis, also class of 36. It now has more than 220 lawyers in 6 locations nationwide. Robbins Kaplan is one of the closest friends and institutional supporters of the law school, with gifts totaling more than $3 million through the firm, as well as the Robbins Kaplan Charitable Foundation. An important and lasting part of their philanthropy has been the creation of the Robbins Kaplan Professorship in Law. The professorship was established in 1986, so over 30 years ago, to encourage and enhance scholarship at the law school. In particular, its purpose is to enrich and expand teaching, research, and scholarship by making it possible to attract or retain a legal scholar of national renown and reputation. I can think of no better holder of the Robbins Kaplan Professorship than my terrific colleague, Heidi Kitrosser. Professor Kitrosser received her BA in political science from UCLA and her JD from Yale Law School, where she won the Harlan Fistone Prize for Best Oral Argument in the Morris Tyler Moot Court. So all you students that have moot court coming up, you know where to go to get some tips and advice. Following graduation, she clerked for Judge William Ray on the U.S. District Court for the Central District of California, and then for Judge Judith Rogers on the U.S. Court of Appeals for the D.C. Circuit. She then worked as an associate in the Washington, D.C. office of Jenner and Block for several years before entering academia, first at Brooklyn Law School, where she taught for 3 years, before we were able to successfully woo her away from the bright lights of New York City. I'm sure she came because of the weather. Actually, it was during that time that I first met Heidi Kitrosser. Through a mutual friend, I heard about a young new professor at Brooklyn Law, and my friend said, "Oh, you should meet my friend Heidi if you're thinking about becoming a law professor." So we met at a little cozy, that fast casual restaurant. I still remember the flatbread sandwiches, and Heidi was very kind and gave me lots of advice. And so I like to think without Heidi, I might not be here. So I'm very grateful to her, and it's been wonderful to be friends with her all these many years. As a scholar, she has authored more than 20 articles and books. with her work published in the Supreme Court Review, Georgetown Law Journal, Texas Law Review, Iowa Law Review, the Minnesota Law Review, among others. And through her penetrating work, she's become known as one of the foremost experts on the constitutional law of federal government secrecy, separation of powers, and freedom of speech. Indeed, she is a frequent media commentator for outlets such as the Washington Post, The Atlantic, CNN, Salon, and others. Her 2015 book, Reclaiming Accountability, Transparency, Executive Power, and the U.S. Constitution, was published by the University of Chicago Press. It received rave reviews and was awarded the ITT Chicago-Kent College of Law Roy C. Palmer Civil Liberties Prize. In 2017, she was awarded a Guggenheim Fellowship, one of the nation's oldest, most competitive, and most prestigious awards for an academic. That award not only reflected the significant influence of her past work, but the promise of her future work. During her fellowship year, she made progress on a book project about the law and policy of information leaking and whistleblowing, a timely and critically important topic, to be sure. But equally important, right here at home in our building in Minnesota, at Minnesota Law, she shares her expertise on these topics with our students. In addition to teaching constitutional law, First Amendment, and government secrecy, she teaches the information access practicum. In it, students work directly with organizations to assist them with government secrecy-related legal policy and public education work, including working on appeals of the denial of information and requests under the Minnesota Data Practices Act, as well as the federal Freedom of Information Act. Today, we all have the benefit of Professor Kitrosser's knowledge, her insight, as she gives the Robbins Kaplan Professor of Law Appointment Lecture. Her lecture today is entitled Committing the Truth in the Deep State. Congratulations, Professor Heidi Kitrosser.
Oh, thank you. Thanks so much. It's so sweet. Well, thank you so much, everyone, for being here. And thank you, Gary. I, too, have very fond memories of that coffee at the COSI. I think it was maybe 23rd Street, somewhere in Midtown. I remember it was an upstairs. It was one of those little, New York places kind of shoved in the upstairs somewhere. I remember it very fondly, and I'm so happy and proud now that to have Gary here as our dean. And thank you for your excellence and your decency and your leadership. I'm also very fortunate, more broadly, to be part of this community, to be part of this law school with its great tradition, great past, and an even more promising present of academic rigor, as well as practical engagement by students, as well as faculty in the community, in the nation, in the world. Also want to very much thank my colleagues. I'm so lucky to be part of this community of scholars, and I'm so even luckier that I've made some really good friendships here, so I'm so glad everyone's here today. Also have to thank our awesome students. We really have just the greatest students. And it's been a real pleasure not only working with students who are here now, but also seeing what students do when they go out there into the real world. In fact, I'll reference a bit later in the talk a pro bono amicus brief that I worked on, and we had some terrific help from local counsel Faegre Baker-Daniels, and one of the people on the appeal was a recent grad. She'd been my student just a couple of years ago. One of the local boards that I sit on, we have a couple of relatively recent grads currently doing some pro bono legal work for that group. So we just have, we're really fortunate here to have a group that is, again, as engaged in the community as they are excellent in the work that they do. Also, I want to echo Gary's thanks to the Robbins Kaplan law firm, which is also a core part of this really thriving legal community. And last but definitely not least, I have to thank my husband, David, who's also my best friend, who's here. I'm really glad that he's here. Okay, so moving into my substantive remarks, what do I mean by committing truth in the deep state? So first, just to back up a little, as you all probably know who are here, our tradition at these lectures is for the speaker to share some aspects of their scholarship. And as Gary alluded to, and as the title probably gives you a sense of, I'm going to be talking about the topic of so-called whistleblowing, and particularly whistleblowing in the federal government. But just to step back for a moment and sort of connect that up with some other topics, and also give you a sense of sort of what brought me to this area. The topic that first drew me to law, way back as far as high school, I can remember having a strong interest in speech and press freedoms. And initially, what drew me in were different controversies about the government penalizing private speakers, members of the press, for, or talking about whether they should penalize them for opining on various topics. Whether, for example, individuals should be prosecuted for flag burning, whether particular types of indecent speech should be prosecuted. And these remain very significant interests of mine, but that said, over time, I began to think more and more about the information that informs our speech, and in particular, information about government. And I began realizing, we can have the freedom to spout off all we want and to share our opinions all we want, but it's not meaningful in a way that sort of resonates with our constitutional values of the rule of law and government accountability if we don't have the ability to inform ourselves about what government is up to, so that when we speak, we're not just, sort of spouting without having an opportunity to really know what we're talking about. So in short, my interest extended. This certainly didn't replace my interest in traditional free speech topics, but my interest sort of broadened to include an interest in government secrecy, government control of information, efforts to prevent people from learning about what their government is up to in the first place, so that even if they have all the freedom in the world to talk, they simply won't have the capacity to talk about the things that hold government accountable and that help maintain the rule of law. And this brought me eventually to the topic of whistleblowing, and in particular, government whistleblowers. Because after all, a whistleblower, somebody, particularly a federal government whistleblower, somebody who comes from within the government with some sort of special knowledge and speaks out, this is really where the rubber meets the road in terms of the nexus between government restrictions on private speakers and government restrictions about the information that we need to know what government is up to. So first, just to step back for a second, what is a whistleblower, right? Because part of the issue when we talk about the law and policy of whistleblowing is who should get to claim that mantle. And there's a lot of controversy about the term. That controversy and my responses to it will be sort of implicit in some of the points I make in the talk. But let me start by defining it in the most abstract way that I think I reasonably can. And this abstract definition would be something to the effect that a whistleblower is somebody who shares information, either with the public or with some select group of people, that about which it could reasonably be said that disclosure is in the public interest, where the whistleblower has a reasonable basis to believe that they may well be subject to punishment, whether prosecution, other legal trouble, job-related retaliation, perhaps termination or demotion or harassment on the job, that they have a reasonable basis to think that they are incurring that risk by sharing that information. Now, when you talk about it at that level of abstraction, it's a little bit hard not to support the concept of whistleblowing, right? Not to support the concept of legal protections. It would almost be a little bit like saying, I hate puppies, right? That, I don't want people to share information that it's in the public interest to share. But that said, the virtues of whistleblowing and the types of protections that should apply become much more contested as we start to get more specific about what kind of information might be released, and more specific about what kinds of mechanisms for controlling that information the government should or shouldn't exercise. So just to give you a couple of examples of areas that are and long have been controversial. There's, for decades now, been support across parties by administrations, again, on a bipartisan basis, for the notion, that is, White Houses for decades now have supported the notion and tried to implement in numerous ways a practice whereby agency employees, federal government agency employees, should not be able to share information with Congress unless that information is vetted by a high-level political official. And indeed, fun fact about this, Theodore Roosevelt, who is often talked about as a real champion of protecting the civil service and a real champion of government whistleblowers, he in fact initiated one of the early gag orders against federal employees, specifically against members of the US Postal Service, to prevent them from contacting members of Congress to talk about their working conditions, pay conditions, things like that. He actually initiated one of the gag orders that eventually led to the 1912 Lloyd-La Follette Act, which actually purports to protect the ability of federal employees to speak directly to Congress. So that's an area where, when you get down into the weeds, there's actually been historically a great deal of support, at least among administrations, for clamping down on this type of what some might call whistleblowing. Another area, perhaps the most intuitive area of controversy, is where national security information is at stake, right? What if the information that's being shared is information that the government has classified? My guess is that when you hear it put that way, you might start thinking, well, I don't know. Maybe that is sort of problematic. Maybe the government should have free rein to punish those kinds of disclosures. So what I'm going to focus on here in the bulk of the talk is I'm going to dig into two of these somewhat more contested areas. One is the national security context, specifically prosecutions, criminal prosecutions of individuals who leak classified information, specifically when they leak the information to the press, to members of the media. And the second context is that in which federal employees face job-related discipline, such as firing or other retaliation in the terms and conditions of their employment for speech that's engaged in the course of doing their jobs. And the second example, I'll talk about it outside of the national security context. And I'll discuss both of these examples through stories. So for each one, I'll talk about one specific individual who faced some sort of penalty in this context. But before I get into the specifics of each story and this area of disclosure, let me give sort of a bird's eye overview of my conclusions, just so you have a sense from the outset of where I'm going. In short, my conclusion is simply that in both respects, whistleblowers in these areas deserve significant protections as a matter of constitutional law, First Amendment law, separation of powers law, as well as matters of good policy. Now, that's not to say either category of whistleblower deserves absolute protection because there are, often important interests on the other side. But it is to say they do deserve some level of protection that demands some degree of exacting judicial scrutiny, and certainly much more protection than, as we'll see, that they've historically received. And the basic rationale for this big picture conclusion involves sort of a couple of elements. At its heart, it gets down to the notion that public employees, and in this context I'm focusing on federal employees, have what I've referred to in another context as special value in particular that they add to the speech marketplace. Yes, that part of their role as federal employees involves being disciplined, being loyal, following orders, doing what their employers want them to do. But there's a flip side, which is that they alone, in many cases, have access to information that their employers might not wish to have them reveal for reasons that are not in the public interest. So oftentimes they may be the only potential safety valve to reveal information that employers wish to keep hidden for reasons that, again, cut against the public interest. And this sounds very much, first of all, in free speech principles, as I'll talk about a little more in a few minutes. While the Supreme Court can't agree on a lot of things when it comes to the First Amendment, one thing that they do agree on is that if there's a core purpose for free speech protections, it is to inform ourselves about government and to be able to check our governors. And so the notion that employers or employees have anything less than robust protections, not absolute protections, but meaningful protections, really cuts against that. And also from a separation of powers perspective, as I've expounded on at length elsewhere, our system very much sort of assumes through various checks and balances that are built into the structure of the federal government, assumes what I've referred to elsewhere as substantive accountability, which is mechanisms not just for people to react, let's say, at the ballot box, but also mechanisms for the people and for competing branches to learn information about what's going on in the other branches in order to make things like ballot box choices or the ability to pass legislation meaningful. Okay, so turning to the first example, national security information and prosecutions, specifically for leaking classified information. So the story that I'm going to talk about involves a man named Terry Albury. And one thing that I want to mention, I alluded to this before, I'm mentioning this partly as a matter of full disclosure and partly, again, to highlight the vibrant legal community here. When I mentioned earlier that I'd worked on an amicus brief, that was for Terry Albury this past summer. It was a sentencing amicus brief, and that was the brief on which myself and my co-authors received really important help from our local counsel at Faegre Baker Daniels, as well as one of their associates, a recent former graduate. So I mentioned that, again, highlight the legal community, but also by way of disclosure. So a little bit about Terry's story to get at this idea of classified information leaks. So Terry, Mr. Albury, is a former FBI agent. It's a local story, by the way, I should add. He was an FBI agent here in the Minneapolis-St. Paul area. He was an agent for over a decade. He started as an FBI intern in the year 2000. And just a little over a year ago, the Department of Justice charged him with 2 counts of violating the U.S. Espionage Act on the basis that he leaked classified information to a U.S. media organization. Now, many of the details of what he leaked, even what which news organization it was, technically remain classified. But that said, one can quite readily piece together from news reports, as well as from the U.S.'s own warrant information, the basics. And that is that the leaked information involved information about surveillance practices, including race-based surveillance practices and surveillance practices of journalists, and that the leaked information, in fact, resulted in some pretty significant, pretty substantive stories in the US press. Now, one former FBI agent named Mike German said of these presumed disclosures by Terry, by Mr. Albury, Quote, most of them were FBI policy documents, and if we live in a democracy, we can't have secret government policies. Clearly, having released them hasn't put our national survival at peril. All it has done is provide the public with more information about how the FBI conducts its business. And clearly there was evidence of abuse, particularly in a lot of the documents about targeting immigrants, targeting journalists. Now, all of that said, Terry Albury pled guilty shortly after he was charged, and he is currently in federal prison. Now, this may seem, somewhat, this may seem not to add up, right? That I just explained that, this arguably was important information that it was in the public interest to know. There's at least a reasonable set of arguments to be made that the leak wasn't harmful to national security. So it might sound strange to hear, well, he pled guilty and he's in federal prison right now. But it actually makes sense when you understand the content of the U.S. Espionage Act. The Espionage Act, which incidentally is about 100 years old and was actually created decades before the classification system even existed, was created essentially to target classic espionage, spying, etc. But nonetheless, the wording is so broad that as applied to the system of classified information, it could conceivably criminalize just about any conveyance of classified information, including to the media. And it doesn't have any sort of, there's no public interest defense. So under the Espionage Act, it's completely irrelevant whether or not the information is in the public interest. The wording as to the level of threat that has to be posed by disclosure of the information is so broad that, again, it's effectively enough. Maybe there could be a few outlier cases where this might not be the case, but effectively it's almost always going to be enough that the information was classified. Public interest, other mitigating factors, irrelevant under the Espionage Act. And so a defendant in Mr. Albury's position is really not left with much to argue if he's not contesting the actual underlying facts of the disclosure. As a matter of First Amendment law, there have been really just a small handful of cases, and in fact only one federal appellate case back in the late 1980s that has weighed in on the constitutionality of the breadth of this statute. But for the most part, including in that appellate decision, courts have been quite differential. They've essentially said, particularly the U.S. Court of Appeals for the Fourth Circuit in this appellate case I refer to, they've essentially said it's classified information, it's national security. It's really not for us to take a heavy hand and look closely at whether we think, for example, the information was really dangerous or not, or whether we think there's public interest at stake. Now, my view is, I think that the First Amendment, in fact, demands significantly greater judicial scrutiny. At bare minimum, some sort of balancing test that takes into account public interest as well as a judicial review of the level of national security harm posed, or perhaps a variant on that would be something akin to a public interest defense. Along similar lines, I certainly think it's way past time, several decades past time, for Congress, as a matter of policy, to amend the Espionage Act as well. And my basic reasons for this are, there are sort of a few tiers to the reasoning. First, as I referred to earlier, if we look at the nature of the speech that's disclosed, certainly allegedly disclosed in Mr. Albury's case, but in most cases involving prosecutions of classified information, this is speech overwhelmingly, I think probably in every classified information prosecution, in fact, where it involved a leak to the media, this is speech about government. This is speech involving the activities of the government, activities that are in an area about which the public, because of the secrecy of the area, are very poorly informed. In all other settings outside of the classification setting, again, courts, as I mentioned earlier, routinely tell us that if there's one core reason why free speech is important, why the free speech and press clauses of the First Amendment should be valued, it's because of the way in which it enables us to inform ourselves about citizens as government. We're also told in tandem with these sorts of rationales in cases, as well as by theorists, not just courts, that a closely related value is the value of speech in enabling to check our governors. So really the only difference in cases like Mr. Albury's or that Fourth Circuit case I mentioned is that somebody stamped the words classified on the information at issue. And my core argument really is quite simple, which is that all of that free speech value, as well as the dangers, the risks of government censorship, particularly about information about itself, those don't all disappear with the wielding of a classification stamp. Now, this is, I think, pretty evident as a matter of theory. Even if you don't know anything about the classification system, it becomes all the more true, though, when you understand how unwieldy and massive the US classification system is. Indeed, this is another area where there has been, for decades, bipartisan consensus. However one comes down on questions of prosecuting classified information leakers, there is broad agreement across parties, across the decades, that there's massive overclassification. Indeed, just a couple of examples. Former Solicitor General Erwin Griswold, who argued the Pentagon Papers case for the Nixon administration, who stood up and argued to the Supreme Court that if this information in the Pentagon Papers is published, it will cause grave damage to the national interest. 16 years later, he published a piece in the Washington Post saying, I've never seen any hint of damage from the publication of the papers, and it is evident to anyone who works with the classification system that there's massive overclassification. As he put it, that most classification is really to prevent embarrassment or evidence of wrongdoing rather than for genuine national security harm. Similarly, Thomas Keane, a co-chair of the 9/11 Commission, had said that in the course of reviewing documents for the 9/11 Commission, he saw things classified that he's also seen in third grade textbooks, that the vast majority of what he saw was wrongly classified. So again, this sort of reinforces what I think is a logical matter, makes a lot of sense, which is all of this free speech value and the dangers of government censorship, particularly censorship of information about itself, that the Supreme Court warns us about and that courts warn us about and theorists warn us about in other cases, doesn't disappear because somebody wielded a classification stamp, particularly knowing the realities of our classification system. I should also add that when something called derivative classification is factored in, there are a few million people who have some level of classification authority in the United States. So that also tells you a little bit about why perhaps overclassification is such an issue. And again, the argument is not that there should be absolute protection, an absolute right to leak. And indeed, no free speech rights are deemed absolute. There's always some level of judicial weighing that occurs. But the argument is also that some robust level of protection, some serious degree of judicial scrutiny is called for. And one more thing I'll say before I move on to the second example, and that is that in addition to Mr. Albury's case, there are broader reasons why this issue is of heightened concern of late. And that is essentially beginning in the Obama administration, there was a massive uptick in prosecutions of classified information leaks basically from 1917 to 1973. That is from the time the Espionage Act was enacted to 1973, there had been not a single use of the Espionage Act to prosecute leaks of classified information to the media. That changed in 1973 when the Nixon administration prosecuted Daniel Ellsberg and Anthony Russo. Got dismissed because of what I'll here politely call shenanigans on the part of the Nixon administration. But then after that, no other prosecution until 1987. And then one more in the George W. Bush administration, about 20 years later. But then in the Obama administration, depending on how you count, there were roughly 3 times as many prosecutions, and President Trump is more than on track to outpace President Obama. So this is of concern, well beyond the particular story I told. Okay, let me just quickly, because I do want to leave time for questions, but I mentioned one other context I was going to talk about, and that is outside of the national security setting. Another area that is often seen as a tricky one is what types of protections individuals should get from workplace retaliation for speech that is work product, essentially, speech that is engaged in the course of doing their jobs, such as writing reports, et cetera. And the story I'll quickly tell here is that's apropos to this category, is that of someone named Joel Clement. Mr. Clement is a scientist and a policy analyst, and he was a senior career official in the Office of Policy Analysis of the Department of the Interior from 2011 to 2017. Mr. Clement specializes in climate change resilience for Native Alaskan communities. And essentially, the focus of his job for the several years, for the bulk of the job, and certainly the several years shortly before he left the Interior Department, had been on relocation of Native Alaskan communities that, as he put it, were literally sliding into the sea as a result of climate change. And he said, I had the opportunity to interview him, and he explained that basically up until the trouble that I'm about to talk about that he ran into, this had been largely a bipartisan effort. He'd worked with Lisa Murkowski, given that this was Alaska, as well as other Republicans and Democrats alike. And he said he actually sort of naively thought this was an issue that would be somewhat removed from politics because it didn't involve climate change forecasting. It simply involved dealing with realities on the ground, such as villages that were becoming uninhabitable. However, in June 2017, with no prior warning, Mr. Clement received an email from the department informing him that he was being reassigned. Specifically, and remember, he's a scientist and a policy analyst, never been an accountant, never had anything to do with auditing checks or anything like that. But he was told for the first time in this email he was being reassigned to a job as an auditor in the office that collects and manages revenue payments for oil and gas leases on federal lands. Well, about a month after he received this notice, he filed a whistleblower complaint with the Office of Special Counsel. And no, it's not that special counsel. Don't get excited. The Special Counsel's Office, or OSC as it's often called, is the small office within the executive branch that handles whistleblower complaints that don't involve national security information. So Mr. Clement, through his attorney, argued that it was a series of statements that he made in the course of doing his job that led to his reassignment to a job for which he was clearly not qualified, clearly had no training, no experience. He argued that it was retaliation for statements he'd made in the course of doing his job. He listed a number of statements. In the interest of time, I'll just give one for example. His statements included remarks he'd made in his capacity as an interior representative to the United Nations just 6 days before his reassignment, to the effect that Alaskan Native, quote, villages are sliding into the sea and the threats are growing. And he listed a few other statements like this that he said he'd made in his capacity on the job. Now, Mr. Clement brought the complaint under the Civil Service Act as amended by the 2012 Whistleblower Protection Enhancement Act, and specifically he relied on a provision that makes it protected whistleblowing to reveal a, quote, substantial and specific danger to public health or safety, unquote. Now, prior to 2012, that provision would not have covered him because prior to 2012, pursuant to some interpretations by the U.S. Court of Appeals for the Federal Circuit, some heavily criticized interpretations, that provision was deemed not to cover people who made the disclosures in the course of doing their job. So if their job was to write a report or to testify to the United Nations, for example, that it was 100% within their manager's discretion to respond to that speech because it was work product speech, however they saw fit. Now, while it's true that the 2012 amendments changed this, as some evidence of why political protections, in this case legislative protections that have to be administered by the executive branch, are far from foolproof. One should know that at present, an OSC investigation, which is what Mr. Clement sought, may not be as effective as it was thought to be at the time all the relevant legislation was passed, because one of the main types of remedies that the OSC can order is review by the Merit Systems Protection Board, which is the body with which the OSC would lodge a complaint if it chose to do that. However, as of, I believe, last Friday, the Merit Systems Protection Board now has 0 members on it. It was without a quorum since January 2017, but it did have 1 member for a while, and it lost that last member Friday when their term expired. So that gives you a sense of the vulnerability of the protections. But nonetheless, the part on which I want to focus is that at least for many years, the statute was interpreted to not cover somebody if they were speaking in the course of doing their job. And that's actually also the current state of First Amendment law. As of the 2006 case of Garcetti v. Savalos, the Supreme Court there also indicated that while public employees continue, as they have for several decades, to have some amount of First Amendment protection against retaliation, such as through firing, demotion, etc., retaliatory reassignment for their speech, the court established in 2006 that under the First Amendment, there's no protection when the speech is engaged in as part of doing your job, as Mr. Clement suggested that he was doing. And the court essentially suggested 2 arguments. They sort of gestured at 2 arguments, although they weren't, shockingly, not crystal clear about exactly what the rationale was, but they suggested first that, well, you know, when you're someone's employee and you're speaking in the course of doing your employment, it's effectively speech that belongs to the government. And then they also suggested, look, managerial discipline would just be impossible if the government could oversee every claim that you know, this work product is inadequate, if that could be turned into a First Amendment claim. Now, while the government speech argument is deeply, deeply flawed, massively overbroad for reasons I'd be happy to get into in Q&A, I'll gloss over it now because of time, the managerial discipline argument does have more merit to it. I mean, that is a real concern. But that said, there is absolutely no reason that courts can't, and in fact, in the context of enforcing statutory protections, at times they have engaged in at least a pretext analysis to determine when your employer says, well, I fired you because that report was just very shoddy work, whether in fact that's a pretext for the fact that the person was in fact simply doing their job consistent with the best practices of their profession, of their discipline, but the employer found the conclusions they reached politically inconvenient. As to why this speech should be protected, I'll just nutshell it here in the interest of time, but suffice it to say, it gets back to what I was saying earlier about the special value of public employee speech. That's really at the core of why it's a mistake to deem speech such as reports, scientific reports written in the course of doing one's job, inspection reports, etc., to deem it completely off limits from First Amendment protection, precisely because that is the kind of speech that embodies the special value, the special insights, the special expertise that only public employees know by virtue of their access to information about the inner workings of government. There's much more that can be said on that, but I'll leave it there. Okay, so I'm going to close now by saying just a few quick words about someone else, a man named Ernie Fitzgerald, who died just a little bit over a month ago at age 92. And among Fitzgerald's distinctions was the fact that Richard Nixon once said of him, as captured on an Oval Office tape, quote, "Get rid of that son of a bitch," unquote. Now, Fitzgerald's transgression took place during his testimony at a 1968 Senate hearing on Air Force cost overruns. Fitzgerald's superiors had advised him to, quote, "play dumb," unquote, when it came to specifics. And so when asked about one particularly damning number, Fitzgerald began trying to obfuscate. But then mid-answer, he had a change of heart. he told Senator Proxmire, who had asked the question, quote, "Your figure could be approximately right," unquote. Fitzgerald would later say that in this moment and in many similar moments that would follow, he had, quote, "committed truth," unquote. In response, President Nixon did get rid of the bastard. He ordered Fitzgerald to be fired. However, unlike Richard Nixon, after 1974, Fitzgerald eventually made his way back into the employ of the federal government, accruing several hard-won legal victories, including eventual orders for his reinstatement and for back pay over the course of nearly 2 decades. Fitzgerald also helped to inspire the first major piece of federal whistleblower legislation in 1978, and he's been referred to as the, quote, patron saint of federal government whistleblowers, unquote. Still, Fitzgerald's road was not an easy one. He fought for years over his job and his back pay and the like, and at one point he was referred to by the Secretary of the Air Force as the most hated man in the Air Force. Now, the note on which I want to leave you, however, is Fitzgerald's statement that his firing offense was that he committed truth. Because I think that any legitimate whistleblower claim, and that's not to say every claim is legitimate, but any legitimate such claim begins there, with a disclosure of truthful information that one's superiors wish to keep from the public or from some select group of people. And in a system grounded in values of free expression, accountability, and the rule of law, decisions to punish such truth-telling by federal public servants ought not to be taken lightly. Now, this is by no means to say, of course, that there are not important considerations on the other side and difficult balances to be struck as matters of law and policy. But deference to the executive already is the dominant norm in these matters. So what's important, I would argue, is that the balance be righted and that lawmakers and courts keep within their sights the rule of law and the accountability values that are at stake when public employees face retaliation for committing the truth. Thank you so much. I think we're going to do questions. Is that right? If anyone has questions? Okay. Yeah, Claire Hill. Professor Hill, excuse me.
So, when you said that this massive number of people had classification authority and that there were lots of stupid reasons why things were being classified, that made me wonder about 2 things. First, I have to presume that smart people have thought about how you constrain classification.
Right.
I wonder if there's anything there that you're particularly optimistic about. Second, I wonder whether there's any possible use for machines in this, that is, robots, AI, machine learning, that could set up perhaps a screening, a presumption to be related, or something like that.
Yeah, that's a great question. So on the first point, as you can imagine, there have been a lot of studies, right, about overclassification. As I mentioned, there's not a whole lot of bipartisan agreement in Washington these days, but for decades there has been agreement that this is a problem. And so this has been something, there have been a lot of hearings actually over the years, going back to, I believe, the 50s was probably the first major congressional hearing. Every decade or so, there's another big hearing as well as private analyses. I think that the core answer that people keep kind of coalescing around is, not surprisingly, incentives, right? And the notion is folks, who have to make these classification decisions, not surprisingly, probably like all of us, especially in the positions like that, tend to be really risk averse. And there's a very strong sense that, if I'm not sure and I classify this, nothing bad's going to come of that, right? So it'll be just another of the million pages, million pieces of classified information. In some years, as many as 90 million new pieces of information are classified. Not really that big of a deal, not a whole lot of harm. And on some level, whether it's subconscious or not, probably won't get back to hurt me, right? On the other hand, oh my gosh, what if I accidentally let this go and this is the piece of information, right, that leads us to lose some, the trail of some important terrorist, or, this is the piece of information that ends up on the front page of the New York Times and it gets traced back to me. So I think it does come back to incentives, and people who have worked in the classification system for a long time essentially keep coming back to saying we have to try to find ways to change the incentives. There's a lot that can be said about that, but just one little smidgen of that, just for example, is that under the current classification executive order, and this is an aspect of the order that's been largely the same over multiple presidencies, in addition to the standards for what makes something classified, there are procedural requirements, including you're supposed to give the reason for the classification and the name of the person making the classification decision. This is very often ignored. And so one suggestion that has been made is, simply cracking down more, right? Doing more audits of, the extent to which different agencies, different classifying persons or bodies are following those rules that can enable them to be held accountable for wrongful classification. And even more to the point, the argument's been made that there should be consequences for wrongful classification. Now, there's an even bigger problem, though, which is that the standards themselves are so malleable, you can probably almost always fit within one of the classification justifications, but that's a little part of it. In terms of automation, I'm a little skeptical about automation on the front end, that is the decision to classify. I think there might be something to it in terms of declassification, though. As you probably would imagine, there are massive backlogs of classified information. Government's always behind by hundreds of thousands of documents in declassifying. So I think automation might be at least a starting point to speed up maybe creating presumptions one way or the other, and then taking it from there. There were some important, I believe it was in 2016, statutory amendments that tried to speed up the declassification process, among other things, trying to kind of speed up the date at which presumptively information becomes declassified, the number of years, et cetera. Oh, yes.
You had mentioned on the work product speech issue that I think you acknowledge the managerial discipline.
Mm-hmm.
I'm wondering I think you said your recommendation was at least a pretext analysis.
Yeah.
I'm wondering if you have a more specific framework that you advocate.
Yeah, sure. And this is another, by the way, I didn't recognize you right away. This is another one of our terrific former students. That's you, Josh, right? Yeah, okay. He's holding his hand up over his face. Sorry to call you out. Yes, so there actually is existing case law to deal, an existing framework sort of outside of this context to deal with questions of, there's a framework that comes up from the retaliatory arrest context to determine, hey, when the cops arrested you, allegedly for jaywalking or something, were they really, was this something they would not have done were it not for the fact that you mouthed off to them before you began jaywalking? And it essentially is a burden shifting framework, much like we also see like in contexts like anti-discrimination law, where essentially the court asks and says, look, was a causal factor in the arrest the fact that they engaged in this protected speech, right? And then they do also a but-for analysis. If it was a causal factor, well, would you have arrested them anyway? So there could be something quite similar to the extent that the agency says, well, this is just shoddy work product. This is just a really lousy report. And then, the inquiry would be something to the effect of, well, was a factor the fact that they didn't like the political conclusion that was reached? And if so, would they have reached the same conclusion anyway, right, absent that factor? And that would involve some analysis such as, did the person use the best practices of their discipline? Was there, actually a basis to think this was shoddy work product? Were there other legitimate disciplinary concerns in play? So they're not easy analyses, but they really are the kinds of things courts do all the time, including, in other contexts like discrimination, when you're trying to figure out why did you really fire this person? Was it because they did a terrible job, or was it because of some protected category or behavior? Oh, yes, Jill. Yep.
private,
Yeah.
and incorporating that as
Yeah.
a whistleblower, because I think that's the same
Yeah.
privacy and confidentiality and embarrassment and retaliation, a
Yeah.
lot of the same things.
Yeah, no, absolutely. So I guess two quick things on that. So one is one of the people that I interviewed in the course of doing some of this research is actually the attorney who's representing Joel Clement. And it was interesting because I discovered in the course of interviewing her that this was actually her first whistleblower case. She had traditionally, and I think continues to take employment discrimination cases. And she told me that her sense is, and this is backed up by some things I heard from some other attorneys, she told me that her sense is, in a lot of cases, people who potentially have good whistleblower claims instead bring only discrimination claims. Not to say they don't also have a discrimination claim, but it doesn't really occur to them that sometimes the same facts that make up a discrimination claim, such as there's horrible discriminatory stuff going on at this government agency, also gives them a whistleblower claim. And her, she could only guess at why that was, that people who might really fall into the whistleblower category where there's discrimination at issue might tend to only bring the discrimination claim. But part of her thinking was that there are just more attorneys who are familiar with the discrimination claims. And there might be other things in terms of the plaintiff's own incentives. But one other point I want to make about that, I know you talked about privacy, so you were talking about things that maybe people would consider private or embarrassing. But I think your question gets at a broader issue, which is, can something be a whistleblower claim if it's about something bad that's going on at an agency, but it's not, the disclosure is not purely because of a sense that this is against the public interest, there's a law breaking or something like that, but also because they're revealing something bad that's affecting them. So for example, I interviewed a couple of poultry inspectors, actually, USDA poultry inspectors, who had run into a lot of problems and retaliation because they kept complaining about health hazards to themselves and to the other inspectors and to a lot of the private slaughterhouse employees on the job. And so there's a question of, do they deserve sort of the mantle of whistleblowing when really they were just trying to help themselves? And I would actually define it broadly enough to include people in that situation, whereas some people would say, no, it's really only whistleblowing if it's not at all self-interested, if you're just saying this because it's in the public interest, not because you're talking about dangerous work conditions that affect you. And that's similar with discrimination as well. Yeah.
I was wondering about your historical statistics regarding, I guess, prosecutions of government employees
Yeah.
for media leaks in particular.
Yeah.
Like nothing between 1917 and 73, and then
Yeah.
sporadic, and then an explosion from 2017.
Yeah.
I was wondering, were government agencies like more self-policing, more disciplined, less
Yeah.
prone to leak in the earlier days? Were the news outlets more respectful of government and less willing
Yeah.
to? I mean, were people trying to leak and it wasn't getting through?
Right.
What caused
Yeah.
the explosion in 2017?
Yeah, it's a great question, and there has been, not surprisingly, there's been a lot written and a lot of discussion about what that might be, and it's there's no magic bullet that answers the question, but there's a lot of speculation, and the two main factors that I've heard discussed the most are one, and this tends to be, I guess you could roughly divide them into kind of the more government sympathetic argument and the more, kind of leaker sympathetic argument. But the more, and I think it's a little bit of both, the more government sympathetic argument is this is a necessary response on the part of the government to technological changes that just make it so much easier and therefore more dangerous to leak. And so the example I always like to give to illustrate this is when Daniel Ellsberg leaked the Pentagon Papers, first, he had to copy them. And this was the early 1970s, right? And if anyone has ever read his memoir, Secrets, if you haven't, I strongly recommend it. I'm telling you, the most gripping part of the whole book is when he describes the photocopying of the Pentagon Papers, because it's amazing. I mean, it took, photographed tens of thousands of individual pages on these old-fashioned photocopiers. If you're old enough to have used these, you have to do one page at a time. You don't put them in a feeder. So this took months and months, and all this kind of subversive sneaking into an office late at night with a friend who ran a travel agency and let them use. Anyway, so this is all to say it used to be really, really difficult to do massive leaks, even to do the photocopying. Chelsea Manning, on the other hand, pretended she was listening to a Lady Gaga CD while downloading, reams and reams of information. So the most government-friendly argument is, they have to do it because it's just getting easier to leak and it's getting more dangerous to leak. The kind of more leaker-sympathetic argument is actually that technology is making it much easier for government to find leakers. That, in the old days, in the days of Deep Throat, you could meet in a parking garage and the parking garage wouldn't be filled with surveillance cameras, right? Now they are. You could go into a government agency or have your source come out of the government agency to meet you and not have to swipe an electronic badge. It wasn't so easy to get, email didn't exist, which is highly traceable. It wasn't as easy to get, third-party subpoenas of hordes of phone lines and email lines, et cetera. I tend to think it's predominantly the latter. I think there probably is a little bit of the former. The government, is very alarmed by some of the really large-scale leaks that technology facilitates. That said, a point that Professor Binkler at Harvard has made is if you look at the prosecutions, particularly the Obama administration, since we now have a full record of 8 years there, they really don't track with kind of leak size, right? It's not as if the administration was just looking for the large leaks. He thinks that the connecting thread between the different kinds of leaks, between the different prosecutions, is that the prosecutions were all what he called public accountability leaks. They were leaks that really were, designed to call out what the leaker thought was some sort of abuse of power. And so I think he's right. So I think there's less explanatory value in the first part, though there's probably something to that. Okay, sure. Oh, yes.
I'm curious about, what I just came to my mind now is amending the Espionage Act to limit it to leaks of things that are not just the lowest level of classification, but some level higher.
Yeah.
Just for a personal story, my father worked for what's now called the Agency for National Development from like 1952 to
Yeah.
when he died in the 80s. And he used to, I don't think he actually ever broke the law, but he used to joke about the stuff he saw that was classified. I mean, he said, if it's not top secret, basically, it's just silly. I mean,
Yeah.
what the Agency for National Development was doing, he didn't have military secrets.
Yeah,
He had information about water production and whatnot.
Yeah, no, and it is kind of hilarious when you see some of the most egregious examples. I mean, there are examples of, newspaper clippings about the Beatles, or, a government report to the effect that, I think this is because of the FBI file on John Lennon. For a while, there was a report classified to the effect that John Lennon is a very popular singer who seems to be, really appeal to young people. So yes, your promise is absolutely right. In terms of possible ways to amend it, well, so I guess two quick thoughts. One is, what's interesting is because the Espionage Act predated the classification system, it doesn't actually mention the classification system specifically. But what it does do is, in very loose terms, say, information that could be damaging to the U.S. national security or to the foreign relations of the United States, and that's closely held. And so the courts have basically said, well, the closely held part in this modern world, we can take that to mean, is it classified or not? But the damage to national security language is so broad that I think the problem is that intrinsically encompasses almost any level of classification by virtue of the fact that it's classified. So I think in amending the Espionage Act, I would be less inclined to say, peg it to a high level of classification, though that could be one possible solution. I would probably be more inclined to just put words in the statute itself as to sort of the level of danger and perhaps the degree of inquiry, right, that you want the court to conduct. Do they have to look in camera, for example, at the information, or can they just rely on a government affidavit, something to that effect? But I think they probably should get more specific than just referencing a level of classification.